Justice Ahmed Mohammed of the Federal High Court in Abuja Wednesday delivers the long-awaited judgment on the suit filed by a court party challenging the constitutionality of the ongoing amendment of the Electoral Act by the National Assembly. The judge says that the Independent National Electoral Commission (INEC) is the only body that is constitutionally empowered to organize, undertake, and supervise elections in Nigeria. He subsequently holds that the moves to alter the election sequence is unconstitutional. Justice Mohammed further holds that the action of the National Assembly is a clear breach of paragraph 15A of the third schedule of the 1999 Constitution as amended. After the proceedings, counsel to a court party, Thomas Ojo, expresses satisfaction at the judgment.
Judgment just delivered is a true representation of the position of the law, and the judiciary, we want to say kudos again, having risen to the occasion expectedly. The position of the court is that the powers given to INEC under the Constitution, particularly section 15A of the third schedule of the Constitution, cannot be taken away by an amendment.
A representative of the Attorney General of the Federation and Minister of Justice, Abubakar Malami SAN, also commended the judgment.
What we have today is a confirmation of the position of the Honorable Attorney General that the National Assembly do not possess the constitutional powers to deny INEC its constitutional powers. I think that's the summary of it all. INEC is constitutionally empowered to organize, supervise elections. And the word to organize, to supervise have been clearly dealt with. So the issue is, can INEC now take that power away by a bill or an act? The position of the Honorable Attorney General is that National Assembly do not possess that powers. And that's what the court has just done today.
However, counsel to the National Assembly, Sebastian Horn, says the judgment will be challenged at the Court of Appeal.
Well, definitely we are going to test the decision upstairs. We are heading to the Court of Appeal because we are not satisfied with the reasons His Lordship gave. For instance, he relied on the obiter dictum in Attorney General Bender State against Attorney General Federation. That was not the ratio in that case, and that decision is decisive of this type of dispute. And secondly, we challenged the local standard of the plaintiff because they did not tender the certificate of registration. We also submitted some Supreme Court decisions to that effect. That aspect was completely left out of the judgment. Sections 176, 132 and the rest have been altered by the First Alteration Act, which places INEC under the feet of the National Assembly.
By this judgment, the INEC sequence of 2019 elections, with the presidential election coming first, still stands. Joseph Kadri, ITV News, Abuja.